Act, license number 170952, registered with the Nationwide Mortgage Licensing System and registry number 813B544. Broadview Mortgage, equal housing lender. Remember, if you never want to make a house payment again, except for property taxes, maintenance, and insurance, that's 800-566-2475. That's 800-566-2475.
News, weather, and talk on KCAA 102.3 FM, broadcasting to the Moreno Valley, Corona, and Riverside.
And now, it's For the People with Judge Herb Dodell.
Well, good afternoon, ladies and gentlemen. We've kind of developed a little routine now of telling folks what the show is about before we start, unless you've listened to all the shows before. And since you haven't, we might as well tell you what we're going to do here today and every other day.
Judge, I've listened to every show.
And I've been watching you. You're staying awake. That's remarkable.
It's very hard today after the Super Bowl, I'll tell you.
Oh, is that why you look so beaten up?
Yeah, I'm wiped out, man. Yeah. Mm-hmm.
Okay, well, what we've done is we've tried to provide the people, because that's why the show is called For the People.
Yes, it is.
With some information, number one, information that gives you an opportunity to understand how the judicial system really operates from the inside, because that's the key here. It's from the inside.
Yes.
Having been in the legal profession since 1964. Wow.
I was 2 years old.
I don't want to go there. But the fact is, the fact of the matter is that there's so much that goes on inside the system that the public doesn't know about. In fact, just talking to your guy Fred a few minutes ago, he's saying, you know what? People don't know anything about how things really work. This is really an eye-opener, and that's what it's intended to be.
Yeah.
So part of it's informational. Information tells you legal concepts briefly and kind of in general, because we're doing this show in California, but people are going to be listening to it and are listening to it in other states, and the laws are different in different states.
In fact, Judge, I'm looking at it right now. People are listening in Russia. Might be Putin. I don't know. Maybe he's getting advice from you. About Vladimir Putin.
Wouldn't be any worse than the advice he's getting from somebody else. So I shouldn't say that. Maybe he's getting great advice from somebody else.
It could be. It could be. You know what I mean?
No, you're kidding about listening in Russia.
They actually do listen in Russia sometimes. I've seen it here. The KCAAradio.com goes throughout the world. So they're listening all over. You want me to tell you?
Who knows?
I'm telling you. I've had people listen in Russia on my show. So believe me, they listen. I had Bulgaria listening today.
Bulgaria is a great country. I've been there.
You've been to Bulgaria?
Oh, I have.
What is Bulgaria?
Sofia is a wonderful city. We had one of the best meals.
And she's pretty hot, too.
Sophia
Sophia Loren, I was talking about.
Well, now you're reaching back at the history.
Whatever.
But Sofia, Bulgaria is a beautiful city. Really is very, and the people are terrific.
Really?
Bulgarians are wonderful people.
Okay, cool. How's their laws over there? Let me ask you something about the law in different parts of the country and the world. Well, not the country, but in different parts of the world. I mean, do we have the best, court system and legal system in the world, or are there better ones out there that you've heard of? Or
Well, in my opinion, we have the best system of all.
Okay.
It doesn't mean it works flawlessly. It doesn't work flawlessly. It's got lots of errors in it, many of which are man-made, meaning that people are just not following what the real laws are, and they're kind of interpreting it the way they want it to be.
Right.
In fact, I always tell people when they're thinking about litigation, I always say to them, what do you think the judge is going to do? First of all, you don't know who the judge is, he or she. What do you think the judge is going to do? There's going to be a very, very important legal question in this case, whether something is or isn't, whether the jury hears it or doesn't hear it. One person is making that determination. And that judge could say, I'm not letting it in. Jury never hears it. Or, I'm letting it in even if it's prejudicial. I want the jury to hear it. So since you don't know what that judge is going to do, that's called high risk. That's really rolling those dice. And when you have a single issue case, and it could go 50% for you, 50% against you, It's time to sit down and figure out what's a good compromise to avoid the risk. It's all about risk and exposure, 100%. Most lawsuits are about money. It means taking more or taking less. You got to show good sense. I started to talk last week, I guess it was, or 2 weeks ago, about various techniques to how to settle cases.
Yeah.
You know, ones like high-low, which we said was not a poker game. Another is by statutory offers. There are ways to work the system, but you need to know what the system is in order to be able to work it.
Well, how have you never been in the system? How do you know if you've never been in the system? You never dealt with it before. Somebody just out of the blue sues you, or you sue somebody out of the blue. How do you know how the system works?
I know this is going to sound somewhat self-serving, but the fact of the matter is you talk to somebody who tells you the truth, who tells you how it really works.
A lawyer you're talking about?
Well, probably not. But no, so, you know,
I'm kidding.
You can't say all the lawyers are that way, but a lot of lawyers will not tell you the truth.
Why is that? Why would lawyers have such bad reps?
Because if you got a case that's going to be a stiff and you're going to lose it, and you got some money, and the lawyer sees you come in and he or she hears about the case, whatever, they have a motive. They have a financial interest in keeping the case going. They want this thing to keep on going, no matter what the outcome.
But that's wrong.
Of course it's wrong. It's morally wrong.
Totally.
But it happens every day.
Can you sue a lawyer if you see they're sort of doing that? Can you take them to the bar association or anything like that if you think you've been ripped off by them? Or is there just no way of really getting around it?
Well, it depends on your definition of getting ripped off.
Well, I mean, if you know that for a fact, or you talk to another lawyer or something like that, say, no, this guy just prolonged it and he was just trying to drain your money, things like that.
That's a discretionary call. It's hard to prove that somebody had the intent, because you always look at intent, to rip you off. Now, if a lawyer knows absolutely for 100% sure you're going to lose because it's barred by the statute of limitations, there's no defense around it, and continues to take your money and not telling you about it, not telling you is an improper act. Can you go to the bar with that? Yeah, if you could show that that lawyer, he or she absolutely knew, and continued to do it and take your money, that's something they might take a look at. But generally speaking, they're going to be, well, we thought it was going to be this way. It turned out to be a little bit differently. We couldn't predict whatever it is. And it's very hard. And legal malpractice cases are very, very difficult, by the way, in case you didn't know that. Because what you have to do in a legal malpractice case to prove a malpractice is you have to prove you would have won. Sometimes, how do you do that? You didn't try the case because it was thrown out or the statute barred it or whatever it may be. How do you prove that? You got to do the case twice. First, to show that you would have won, and then secondly, that if these people hadn't done it right or had done it right, the result would have been different.
And then you got to get another lawyer to prove the malpractice case.
And then you got to get a lawyer, and most of them are all going to be on contingencies.
Right.
Meaning that the lawyer has got to really believe in it before they take that kind of case, because otherwise they're going to spend a lot of money. And legal malpractice cases are expensive for those of you thinking about it. And the reason is you need an expert. You need a lawyer or a judge or somebody who has had the experience in that particular field.
And that costs a lot of money.
Yeah, you could figure on any decent-sized case. Any decent-sized case. We're not talking about a $5,000 or $10,000 case.
No.
We're talking about a potentially six-figure case. You're looking at spending $50,000 with an expert.
Jeez.
And then you got to get into the expert with who's the forensic accountant. And they do the same thing. I think I told you I had a case in Arizona. The bill from the accountants, the forensic accountants, was over $300,000.
How's that going, by the way?
I don't know. Under submission.
Under submission still.
It's definitely under
the jury's
submission.
still out.
No jury.
Well, I know the judge.
A judge of one. But I will tell you that I've been in front of a lot of judges over all those years.
Uh-huh.
I like this judge.
Okay.
This judge had a really nice energy about her. She was just, she was attentive. She was listening. I think she's willing to analyze the issues and not take the easy way out. I had a really good feeling about her.
Well, good luck with it.
Yeah, well, it'll be nice. It will be nice.
It will be nice.
Positive thinking.
Positive energy.
So we're talking about what the show provides. One is information.
Yes.
So today we're going to talk a little bit about what is a contract. How do you enforce a contract? Is there a difference between a written and an oral contract?
Yes, is there? I'd
Things
like to
like
know
that.
that. That's a very important question to me, a written and an oral contract.
I'll get to it.
I know you're going to get to it.
The second
you got
part
like
of the
45
show-
more minutes to go.
The Your inspiration.
Yes, I am.
But the contracts are different than torts. So you say, what's a tort, right? You want to know what a tort is?
Sure. I mean, can we do it after the break? Because you're going to have to get a break in about 30 seconds.
Oh.
How do you
okay.
spell tort? T-O-R-T?
T-O-R-T.
It's not T-A-R-T like tart.
No.
It's not like a pop tart.
I was going to tell the story about the apples, but then I changed my mind. It was apple tart. It wasn't going to work.
All right. It's For the People with Judge Herb Dodell. If you have a question for the judge, you go to askjudgeherb@gmail.com.
This is true.
This is true. All right. We'll be back right after this. Or the judge will be back. I'll just be sitting in.
1050 AM, KCAA.
Herb Dodell is a lawyer and a judge for the people. Having served as a Superior Court judge, presiding over more than 9,000 cases, he has witnessed firsthand how complicated and corrupt the legal system can be. His goal is to show how things really work in the legal system, so that people can navigate the legal system in the best way for them. Many people often feel marginalized by the legal system and are uninformed about how to proceed when unfortunate circumstances arise in their life. Judge Herb will pull back the curtain, lift the veil, so people can truly understand their rights, have access to top legal personnel that they can trust, and have knowledge about how things work so they can make better choices. Judge Herb isn't just knowledgeable. His integrity and spiritual values are truly what make him different. He cares about democratizing access and information for all and desires to turn on the light so the people, you, can benefit. For more information, email the judge at askjudgeherb@gmail.com. That's askjudgeherb@gmail.com.
Okay, welcome back. So let me just give you a definition, because part of the information process is to enable people to process it and be able to use it as part of guidelines if they're involved in that system. So if you've got a contract case, we're going to talk about that today. It's not only information about what a contract is in general terms, without being too overly specific, but how do you use it if you're faced with a question that we're going to talk about called the parole evidence rule. Parole does not mean you have to wait until you get out of jail to use it. It's parole means verbal. Okay. So you asked the question, is there a difference between a written and an oral contract?
Yes, I did.
Actually not.
Really? But hold on. Let me ask you a question about this, because this is very important to a lot of people. In fact, I got sued from somebody who said I said something which I never said. It was never written down. There was no written contract. He basically accused me, and I've talked about this on the air before.
Baldy the Clown.
Baldy the Clown. Baldy the Clown. But anyways, he sued me in Superior Court. Then I went to People's Court, and was on there. But he basically said that I promised to pay him to come on the radio show, my Controlled Chaos radio show. There was never any discussion about paying him, but he said I did. And that's like an oral contract, isn't that? If he says that I said that I was going to pay him, isn't that an oral contract?
Well, you have to assume it's a contract. A contract requires something called consideration, meaning that you're going to do something for the other party or not do something, and the other party is going to do something in return. They're going to either perform some service or refrain from doing something so that you have both parties have, as the term is, the meeting of the minds. In a written contract, none of this testimony would have been admissible because it would have tended to vary the terms of a written agreement. There are only a few occasions, that's what's called the parole evidence rule, where you can bring in testimony that goes beyond what's called the four corners of the document. That's the parole evidence rule. Now, you can do that to explain an ambiguity, meaning there's a term in that contract that you can say, well, it could mean A or it could mean B. Well, you're allowed to bring in testimony, which would include contemporaneous conversations, documents, notes, memos, and things like that, to show what the parties intended that term to mean. But you cannot say that, oh, it says in the contract you're going to give me 12 dozen eggs. You can't bring in evidence to say you're only going to get 9 eggs, because that varies the terms of the agreement. But you can use it to explain inconsistencies. To some degree, you're allowed to do that. You can do it and show potential fraud. It's admissible under certain circumstances for that. But generally, the written contract is better because you have a writing, obviously.
Exactly.
It says something.
Yeah.
And to vary that requires the implementation of this rule. An oral contract, on the other hand, putting aside the evidence, the proof of the oral contract, is basically two people say this is what happened.
This is what I'm saying.
But there's something called, believe it or not, called the statute of frauds. It goes back to, I think, the 14th century in England, which basically talks about changing terms of agreements. Certain agreements must be in writing, or based on the statute of frauds cases, you can bring in for example, a memorandum. If the memorandum stands on its own and is sufficient in terms of the terminology and the obligations, whatever, that goes to proving the oral agreement. And you get past the argument of the statute of frauds, which requires things to be in writing in certain cases. Like a lease, for example. A lease cannot be oral if it's more than 1 year.
Okay.
1 year.
All
Most
right.
people don't know that.
I didn't know that.
You know it now.
Now I do.
So next time you renegotiate your lease, you'll know.
Okay. Well.
But anyway,
So I can just say, I can just tell my my tenant that, hey, I'm gonna raise your rent by $100, and I can do that verbally. If he's been in like 3 or 4 years in
well,
my.
there are a lot of variables. Now, one of which is rent control. Now, people who live in
No, I understand.
in Idaho don't know what rent control is. Probably don't know what rent control is. We sure do know what it is down here.
Oh yeah. There is no
saying-
rent control here. It's
Well,
out of control.
Well, what I was saying is that a lot of the principles that I'm going to talk about, I talk about in general terms because I'm talking California or New York law.
Right.
Those are the two states I have a license in. It may not be the same in other parts of the country. So if you're going to rely on any of this, which you shouldn't do, you should follow up with a local lawyer or even check the internet to see if you have the same rules and regulations. For example, restraining order cases, most states have case law for domestic violence, but they don't have general restraining orders for harassing conduct. So when I talk about restraining orders, I'm talking about California requirements. It may not be the same in Colorado or in other places. So you have to look to see what your local law is before you rely on anything.
Let me ask you a question about the oral agreement. Okay, so in my case, let's take my case because this is this could happen to anybody. Okay, this guy came on my show and said basically to the judge that I promised to pay him on a weekly basis, that we discussed this 2 or 3 times a week for like a year and a half, saying that I made an oral agreement with him to pay him, okay, which I never did. Complete lies. I mean, can anybody just go into court, like small claims court, and accuse somebody of something like this and say, oh, this was an oral agreement. They promised to give me this, this, and that. I mean, how does a judge determine, a judge like you, determine what's right and what's wrong, what's the truth and what's not the truth?
Well, first of all, there's something called the burden of proof. We started talking about that, and I want to repeat it. I should repeat it every week.
You should.
Because 90% of the cases, well, maybe a little bit less, are determined by what's called the burden of proof. Here's an example. A gift and a loan, okay?
Right.
You got a couple that have been together for a while, they're not married, whatever, and now they break up, and the guy's leaving, and he wants this wonderful thing that he bought for them. She says, no, you gave it to me as a gift. And he says, no, I just loaned it to you in the meantime, but now that the deal is off, I want it back. What do you do? Well, I've heard hundreds of cases like that over the years. Here's a great example. Good, fun example. Lady comes in. She says, when I met my husband, he wanted me to have big breasts.
Ain't nothing wrong with that.
So I did the augmentation. I put them in, and I did the whole deal. And now we're gone. I don't like them. I want him to take it out.
Get out.
A true case.
No way.
Oh, absolutely. It was.
How big were they?
It was I'm not going to touch that one, and that's no pun intended.
Yes.
Because people are touching them and getting in trouble these days. Let
me see if those things are real or not.
Ask Al Franken.
Oh, I know.
But the bottom line was you have to listen to the testimony. What was the intent of the parties at the time that it took place? I had a case involving a bicycle.
I want to hear about the breast. Hold on, let's hear about the breast. So what?
Anyway, so she says
the bicycle.
She wanted him out, and he says, "You know what? I gave him to you. You want to take him out? Go take him out on your own nickel."
Oh, so she wanted him out.
Yeah, afterwards they broke up.
After they broke up, she's like, I don't want your...
I didn't want him to begin with, but I was trying to make you happy.
Oh, are you kidding me?
True story.
Wow.
True story. I'm trying to remember where it was. I think it was in Torrance.
Are you get out of here? Usually it's the other way.
Crazy.
You want her to the guy wants him out.
He wanted him in the beginning.
Right.
That's why she did it.
Okay.
But now she wanted him out, and he said, "I'm out of here. I'm not paying for it.
I'm not paying for the surgery to get him out."
That's right. Do it yourself.
Oh, how did you rule?
What do you think I ruled?
I think you ruled.
What do you think, ladies and gentlemen out there in the public? What do you think I decided to do?
Did the judge decide to make him pay to get him out, or did the judge say no? It's your problem, ma'am.
Okay. The answer is.
Hold on. Let me take a guess.
The answer is.
Let me take a guess.
Drum roll. Let's have a big drum roll. Oh, that's very good. We got sound effects now too.
Yep.
Good.
Go ahead. I say you said, hey, you know what? You got him in there. I'm not going to make him pay to get him out. I think you rolled against her.
You're right.
Of course. Why?
Because it was a gift.
Exactly.
He certainly wasn't loaning him. This was definitely a gift. And so the bottom line was, if she wanted to do something about it, she could do something about it on her own.
Right.
He didn't make any contractual obligation that he was going to do this or it was lifetime or anything else.
She didn't. I mean, she could have refused him.
Well, they could have resolved it. Not that because we talked about it last week.
Uh-huh.
They could have resolved it by having an agreement saying, you want these in here now and I'm willing to do it. But if we break up and I want them out, you agree to pay for them. That would have been an enforceable contract.
That would have had to be a written agreement, correct?
No, it could have been an oral agreement.
But how do you decide that, Judge? You have
to listen to the evidence. And I was saying earlier, evidence is what gets considered.
Let me ask you something. How she said, well, we had an agreement saying that if we ever broke up, that he would take him out for me.
If I believed her,
okay,
I might have gone her way.
Okay, all right, just curious.
But see that.
But if it was if they had a written agreement, like it was written.
Right, written agreement is enforceable.
Then
unless it violates public policy.
Then you would have ruled for her.
I would have ruled for her if they had a written agreement that said that.
That's a huge. See, that's what I'm talking about. Written and oral agreements. That's a huge difference.
Well, the biggest difference is the statute of limitations. A breach is when one party does not perform, generally. And that's called a breach of the agreement or breach of contract. What happens then is the party claiming that they had a contract that was breached has to prove it. The contract fairly well speaks for itself as to what the obligations of the parties are supposed to be, unless it's vague. And then you get into the argument of the parole evidence rule. But for the most part, on a contract case, if it's in writing, it's a 4-year statute of limitations, at least in California and as I recall, in New York as well. But on a breach of an oral agreement, it's 2 years. So when I'm sitting in small claims court, which is what I've been doing, I look to see how long after the breach the party took to file the lawsuit. There's a little box in the upper right-hand corner of the claim that says when it was stamped by the clerk. So it'd say it got filed on January 3rd. It'll say January 3rd right at the top. I'll see it. And in the questioning or even in the description that people give when they file a small claims court action, it's going to say, I did such and such and such and such a date he didn't do this or she didn't do that. Well, if it's been more than 2 years from that breach, that's barred by the statute of limitations.
Oral agreement.
Oral agreement, 2-year oral agreement.
Okay.
I have ruled in favor of defendants who didn't even show up because I looked at the complaint and I looked at the filing date and it was more than the statutory period of time. So when you're a plaintiff, it doesn't mean you win automatically.
So if you wait 2 years or over 2 years,
2 years and 1 minute,
and for an oral agreement, statute of limitations run out.
Well, for a breach of an agreement.
That's what I'm saying.
But there are other possibilities that come in. There's something called account stated, where you send a bill every month. There's a different statute of limitations for that.
Yeah.
Or account stated, or other things that have different statutes of limitations.
Because you're still contacting the person, correct? Is that the reason?
Well, generally that's the reason.
Yeah.
Now in a tort, it's a little bit different, and we'll talk about that after the break.
We got to get to that tort.
Yeah. Okay. It's all in the book, by the way. The book is called From the Trench to the Bench, and it's at Amazon, and it's a good read.
It is. It's a great read. All right. We'll be back with more with Judge Herb Dodell for the people right after this.
NBC Talk Radio, 1050 AM, KCAA.
In his book, From the Trench to the Bench, Judge Herb Dodell demystifies the legal system, including both civil and criminal, the lawyers, the judges, and the process. As a judge, former deputy district attorney, and criminal defense attorney, he knows the legal system. He has the inside information that you need to pick a lawyer, and he's here to give it to you. No matter what you're facing that makes you think you may need a lawyer, Judge Herb will shed valuable light on your situation and reveal your best options and many secrets of how the judicial system actually works. To find out more about how the legal system really works, you can get your copy of Judge Herb Dodell's eye-opening book, From the Trench to the Bench, at Amazon.com.
Okay, we're back. We're going to talk about torts now. What is a tort? A tort is a civil wrong. Most automobile accidents are torts. Negligence is a tort. And so the statute of limitations for negligence in California, a car accident, is 2 years. Assault and battery are torts. Same thing. Conversion, taking something belonging to somebody from somebody else, that's a tort. That has the same statute. But the lawyers in California managed to lobby a shorter statute of limitations for legal malpractice. It's a year.
Of course.
So, any lawyers who are listening to the show, you want a surefire way to get sued? Guaranteed? Sue for your fees. So what you should do, just a little guidelines, what you should do is wait for a year and 1 day before you go after collection of those fees, because by then it's too late for the former client to sue you for malpractice. They can generally seek an offset to reduce or eliminate what you're claiming, but they can't sue you for legal malpractice anymore.
Judge, I
That's
thought this was
done.
for the people, not for the lawyers.
Well, I'm trying to think of a clever response for that. But the fact of the matter is that's the way it works. Certain kinds of professional negligences are have a reduced statute of limitations. The purpose of statute of limitations, by the way, for those who never thought about it.
Yeah, what is the reason?
Because evidence gets stale as years go by, and witnesses disappear and things like that. And so in order to keep things within some reasonable range of predictability, you establish a statute of limitations. If it's stale evidence, it doesn't get in.
Let me ask you a question. There's statute of limitations for everything.
Pretty much.
Criminally, how would you change some of these laws? Like what law would you change for the statute of limitations? Like the statute of limitations for murder is there is none. That's what I'm saying. But for rape, what is it?
I don't know off the top of my head. It's been a lot of years since I've been doing it.
What I'm trying to say is that there's weird statute of limitations for different crimes. Do you think there are? Do you think that should be a little bit different? Do you think the law should be written a little bit different for like really heinous crimes like rape and assault and sexual assaults and things like that? Because I mean that it's prevalent in our society now, and a lot of these guys that are getting away with it in Hollywood and whatever, Congress and big business, they're getting away with some of this stuff.
They're getting away with it on a material level, but they're not getting away with it where it really matters.
Well, criminally, they're getting away with it. Come on, they're not going to jail.
But on the other hand, and I don't take a position. if you look at some of these events that are now coming out, these events took place 20 years ago.
I understand that.
It's not fair to the defendant to put him or her in a position where they have to go dig up something 20 years old that they could have used in their defense.
Just playing devil's advocate, Judge.
Yeah, well, there has been an ongoing movement now to change some of the statute of limitations because things are being preserved better now than they were before.
DNA.
100 years, DNA has got more people off of death row than anything else.
That's right.
DNA.
That's right.
A lot of wrongful convictions out there. And it's because, and I speak as a former prosecutor, you're looking for the very best, and you don't always get the best lawyers on the other side.
Let me ask you a question. I mean, as you being a prosecutor, former prosecutor and stuff, I mean, is it that important? I mean, don't you want to find the truth in the evidence and make sure that this guy is not wrongly convicted instead of getting a victory? It seems like a lot of these lawyers, prosecutors especially, and district attorneys, and you hear about it all the time with all different cases throughout the country, that they're looking for the win at all costs. They want to win at all costs. They want to get the conviction at all costs. I mean, why is it so prevalent, especially in the district attorney's office, prosecutor's office? I'm not saying all of them, but why does this happen a lot? You hear about it all the time where somebody's wrongly convicted or wrongly accused.
Well, ideally, it should be looking for the truth and to make sure that justice is done. That's the ideal. And a lot of prosecutors feel that way. I've had prosecutors drop cases after there's been some discovery, not in the formal sense because there's no real discovery, but after people have been interviewed or they've developed evidence or whatever. I've had many cases on both sides, as a prosecutor and as a defense lawyer, where the DA has basically said, okay, you know what, I don't have a case here. And it goes away. And then there are, generally in smaller jurisdictions, when the DA's office is a political job where you get elected, you got a case that's getting a lot of press locally, and everybody wants blood. They got this poor son of a bitch did something, so they're gonna, and that's the way it happens. And the prosecutor or the soon-to-be candidate for the DA's job sees an opportunity to get the kind of publicity and headlines that it takes. They want to see a hanging prosecutor
to further their career. Let's get real.
Yeah, and it's not only a career, because once you leave there, you go into private practice. Some firm's going to snap you up because you got a reputation. You're one of those prosecutors that doesn't ever lose. I had some guy once tell me that he had won 200 straight.
Yeah, but
and I said, no way.
Yeah.
No.
Come on.
No conceivable way. There are cases that you think you're going to win and you don't, and there are cases that you lose that you said impossible that you could lose, and you do.
So
it happens all the time.
I don't understand how somebody can have a good conscience and convict somebody that they know is probably not guilty. And I'm sure it happens a lot.
It happens more than it should.
I know.
But the problem is that's a moral decision, and whether it's business or it's criminal or whatever it is, it's always supposed to do the right thing. You're not supposed to decide what's good for you. You're supposed to decide what's right. And when you do what's right, it bounces off that mirror up there, we talked about.
The karma mirror.
It comes back down to you being in the right place at the right time. That's exactly the way it works. So we were talking a little bit earlier about consideration as a contractual element. In order to have a contract, it's got to be between two or more people. Yeah, that's how you start. Each party doing something for the other or not doing something at the request of the other to make something the bargain. It's the bargain. And at that point, it's called consideration. Every contract must have consideration. It must have a certain time period when the contract is to be performed. You can't have it maybe be performed in 40 years. You have to have something definite in terms of terms. Same thing as the amount of money that's being paid or what is going to be provided or how you identify it. That's all called consideration. And I told the story in the first show that we had. I'm going to tell it again for those who haven't heard the first show. This was a real case. Lady was suing a guy. He gave her a stiff $1,000 check. You remember the story. Gave her a bad check for $1,000. And he wasn't there, but she was. And so we have what's called a prove-up. Prove-up means we have to hear a little bit about the facts to see whether or not it meets legal standards. So I said to her, okay, you got this $1,000 check and it bounced, right? Right. What do you do for a living? She says, I'm a dancer. I go to people's houses and I dance for them. I'm an exotic dancer. I'm already thinking to myself, but, I'm listening to the story. And she says, I went there and I danced for him, and he said he didn't have any cash, and I don't take credit cards. So he says, would I take a check? If I take a check, I'll get paid and he'll give me a big tip.
Yeah.
I'm sure that's not the only tip that she got.
Well,
But
that's
whatever.
Bada bing.
Got to throw a little humor in there whenever humanly possible. And so the check bounced. It literally was a stiff check.
A stiff check.
It
huh?
was. So I said, "What do you normally charge?" She says, "I get $250 an hour." I said, "The check is $1,000, okay?" So I'm saying I must have been a hell of a dance. But the bottom line was, in California, and it's probably the same in many states, if you get a bad check and you write, or probably even email today, because it's notice, it's about notice. If you notice the other party that this is a bad check, and if they don't make it good within the 30 days, you are able to recover 3 times the amount of the check plus the amount of the check. So she was seeking $4,000 for this dance.
Wow.
And
Now that's a hell of a dance.
That was horizontal mambo. I'm sure that's
Among other things.
But I can't get into that because I can't determine what is really beyond the record. It was none of my business what they were doing.
Right.
Unless there was some real evidence of a crime being committed, then you can't enforce the contract. But this was a contract. She did whatever she did in exchange for which he promised to pay her, and that is consideration from both sides. The terms were there. There was definiteness in the contract, when it was going to be performed. Everything was all there. And so whatever the motivation may have been was really not relevant. So what do you think I did?
You ruled in her favor, of course.
I did.
Of course.
I gave her the $4,000.
Did the guy ever pay it?
I have no idea. One of the things people should know that small claims court, you get a judgment
Right.
when you win. It's only about money in small claims.
Yes.
Well, I'm going to talk about a couple of little nuances today because I think it'll be helpful to the public to know this. They generally don't know this. More than generally. Most people do not know what I'm going to tell you in a minute. The fact of the matter is it's always usually just about the money. And it depends on what the judge thinks about all the facts as to whether you're going to get the money or you're not going to get the money. It's just a judgment call, and we follow the rule of burden of proof. Like with gifts and loans, my personal view is that the party claiming that it was a gift, in other words, not giving it back, has the burden of proving that. And how do you do it? By intent. They were together for so long, or they both used it, or whatever the facts may be. Each of these cases is going to be different depending on what the facts are. I had a case involving a guy, he said he loaned his bicycle to a friend who was having a problem with his. And something happened between them, and they kind of had a falling out. The guy wanted his bike back.
Reasonable.
And the other guy said, "No, yeah, you gave me the bike." He says, "No, I didn't. I lent it to you." So you're faced with, well, what was it? And whenever you're in a position where you don't know, then you have to rule against the party with the burden of proof. And that's exactly what happened with the bike. I told him, I'll tell you what, you got 2 choices. Give him back the bike, or keep the bike and you pay him the reasonable value.
You gave him
It's
back
not
the bike,
unique.
I'm sure.
You
You don't even know that one.
No,
either.
we don't-
You
we don't-
You don't. After you judge it, after you make the judgment,
We're done.
You're done, right?
Well, generally speaking, we're done.
Yeah.
And that's what I was saying about collection. The court doesn't collect anything. You get a piece of paper. It says judgment. Now go out and collect it. Go find where the assets are and try to collect the money that you just got in the way of a judgment. That's why a lot of people don't show up. They don't care about the judgment.
yeah.
Although it's terrible to have on your record, it ruins your credit. On your FICO score, you see judgment. It's bing, bing, bing. That doesn't do you.
Really? So it's bad for your
no,
credit.
it's
So
terrible.
you should show up, regardless.
Yeah. Well, I did pretty much the same thing with a car. Guy was having a horrible time with his car, putting the lemon law, which we have in California, aside for the moment. He kept bringing it back, and they kept saying they're going to fix it, and they never fixed it. He was leasing the car. And he came in, he says, "You know what? I don't want this car anymore." So here's some concepts for you. What I did, what do you think I did?
I think he probably made the car company give him a new car or his money back, one of the two.
Well, he used the car, so
Okay, so he probably made the car company pay.
I made them take the car back.
Right.
That's called rescission.
Uh-huh.
That's the legal concept called rescission.
Yeah.
And we can do that under the code in California. We can decide to rescind a contract. We can reform a contract. Reformation means the parties agree that these terms are not properly stated, so they're going to fix it. We could order specific performance, meaning you have to do something, and we'll talk about that right after the break.
All right, it's for the people, Judge Herb Dodell. If you have any questions for Judge, email him, askjudgeherb@gmail.com. His book, From the Trench to the Bench, Amazon.com. We'll be back right after this.
NBC Talk Radio, 1050 AM, KCAA.
Did you ever meet a lawyer that was for the people? Someone who had the best interests of the people at heart? Herb Dodell has been a lawyer for more than 50 years and has been a Superior Court judge for 9 years, having presided over more than 9,000 cases. In this show, he will reveal the secrets of how things really work in the legal system, so you can maximize your position and benefit most when you're in trouble and need someone on your side to simplify the process for you. For more information, email the judge at askjudgeherb@gmail.com. That's askjudgeherb@gmail.com.
Okay, just before the break, we were talking about what the small claims court can do for you. It's a great place to be for all the reasons that I lay out in the book. You can get relief in small claims court that you never thought about, like returning something. You sold something to somebody and they didn't pay you. You can get your article back, whatever it may turn out to be. Sometimes you could even make money on it because it has a sentimental value. Even though that may have been considered in the original deal, you want it back because it means something to you. And now that you didn't get paid, you want it back.
How if somebody thrashes something?
Well, that's a damage. That's a tort.
Okay, so that's a tort. That's what I'm
That's a
asking.
tort.
Okay. All right.
Negligence is a tort.
Okay. All right.
In other words, if somebody hits you in the rear on the freeway and they were texting at the time, that's a tort.
Okay.
That's called negligence.
Okay.
So what does negligence mean? Negligence means something that is done below the standard of care in the community. It's something that people shouldn't do, and they do. That could be negligence.
Like a DUI, and you hit somebody. Is that a tort or no?
Well, it's a crime, actually.
Okay. All right.
It's a tort also.
Right.
And in fact,
Because a lawsuit, there could be a lawsuit involved here.
Might very well be a lawsuit. But there's a question between gross negligence and regular negligence. This is why you need a lawyer, because there's a big difference between gross negligence and there are certain things called non-delegable duties where you can't say, well, somebody else is going to do that. You're not allowed to delegate to somebody else and escape liability. And so in a car accident that's caused by a drunk driver, that could probably be considered gross negligence. Gross negligence allows for the possibility of punitive damages. And I was listening to one of the shows recently, and I didn't really go far enough when I was talking about punitive damages. Punitive damages are not only meant to punish, punitive meaning punish, the party that did it because it was either willful, malicious, and conscious disregard of another person's rights. That justifies the imposition of punitive damages, but it's also out there as an example to others. That's the part I didn't discuss before. To others, don't do this, because if you do, you're liable to get hit just like these guys got hit. And so punitive damages come about as a result of gross negligence.
Okay.
Simple negligence is, you were turning left and you misjudged it and you should have done better or whatever it may have been. That's regular negligence. And the way it works in a jury trial is that the court, after meeting with all the lawyers, decides what to tell the jury to do. They're called jury instructions. A jury instruction is, ladies and gentlemen, in this case, such and such, such and such. And if you find such and such, then you need to do whatever it is. It's basically telling them what to do. And there's a jury instruction on gross negligence. There's a jury instruction on punitive damages. But you got to get the judge to give it to the jury. And if the judge says, nah, I don't think it rose to the level of anything like that, they don't get that jury instruction. And that's usually what leads to appeals. The judge should have said something, or the judge did say something that he or she shouldn't have said. That's a fair amount of the appeal, especially in criminal cases. In civil cases, a little bit differently because there's so much more discretion.
Right.
On
The evidence
factual,
is different. Yeah.
Factual.
Yeah.
But the whole thing, if anybody wants to know why you should settle cases, it's because you don't know what evidence is going to get in and what's not. A judge is deciding, I'm not going to let the jury see that photograph. And your whole case is based on it.
Right.
Don't you want to settle that case?
Yes.
Sure you do. Because you don't know whether that judge is going to let it in or not.
Yeah.
And a lot of them are not going to tell you in advance, although in many cases they do. Parties will see a problem with a particular piece of evidence. They'll request the court to exclude it. The other side says you shouldn't exclude it because it should get in. That's called a motion in limine, L-I-M-I-N-I-E, limine. And you don't know what that judge is going to do. The judge says, okay, I'm going to let it in. Boom. You got to review the rest of your case and say, what effect is it going to have? Or the judge is not going to let it in. Then you take the handkerchief and you wipe the sweat off your brow. I've kept stuff out. I mean, I had a burglary robbery case. The largest one in Orange County was several $1 million. My clients were holding on to gold jewelry for the clients, and they were supposed to give it back when the client wanted it. And what they were doing was they were using it and investing in some scheme someplace in New Mexico. And a lady came in. Her name was Christmas, Helene Christmas.
Wow.
I'll never forget it. Never forget it. And after they arrested my client for setting up this phony burglary, because he said he was robbed, and
Right. Get the insurance money.
No, just to avoid being arrested for stealing all everybody's gold.
Oh, okay.
And so in his car, one of the partners had written a note to the other partner, and it said, Christmas came early. He was just joking around because Mrs. Christmas came in without giving him a lot of notice. And boom, I kept that out. You imagine what that would have done if that had gotten in front of the jury?
Yeah.
Terrible.
Yeah.
We had a ledger of payoffs that one guy was paying another, and they kept records. Go tell how brilliant they were. They were keeping records, and at the trial, they wanted to bring in to show that these people were stealing millions, and they had records of it. How many was taken, how many dollars it was taken, whenever it was taken. And I was able to keep it out.
How?
On the grounds that they couldn't prove who the author of the book was, of the ledger. That guy was living in Canada. And
lucky for you.
It was not anywhere where anybody could take his deposition
right.
or otherwise. They could have taken his deposition, it would have gotten in.
Yeah.
But nobody did.
Wow.
So I made a motion in limine. It was a federal criminal case. I made a motion in limine to keep it out, and the judge agreed. So you don't know what's going to happen on any given day. There are two levels. One is the judge. You got to get past the judge. People say, well, can the judge really make a difference? The judge makes all the difference in the world. What gets in and what doesn't get in,
it's crazy.
Up to him or her.
It's crazy.
How far are you going to, they say, okay, you got 15 minutes. But I need an hour. You got 15 minutes.
Yeah, if the judge doesn't like you, you're in trouble.
Yeah, that's probably true.
Right?
Come
on.
It's not always so overt, but I believe it's true.
Oh, it is.
I've said this before on the show. I never let it get in my way. I don't. Whether I like somebody or I don't like somebody. I remember a lady. She was really nice, and she got hit on the freeway. A piece of cement hit her in the head or something like that. It was obviously from construction going on, and the Caltrans people were there. They were defending the case, and I liked her. She was a very nice woman. But I couldn't make the connection between the concrete done as a result of negligence of Caltrans versus anything else in the world. I couldn't make the connection.
You can't say it was from Caltrans.
I couldn't because there wasn't enough evidence to support it.
Wow.
And so even though I liked her very much, and I didn't like the bureaucrat who they sent from the Caltrans. But that made no difference to me. I ruled in favor of Caltrans.
Oh, Judge.
I felt that. No, but I think, the thing is, I've heard probably 10,000 cases, I guess, over the 8, 9 years, almost 10 years now.
Right.
And I remember them every now and again. If something triggers off a memory, oh, I remember that case. And I can honestly say that I cannot think of a single time in almost 10 years that I ruled in favor of somebody merely because I had a personal feeling.
Well, that's great.
But I can't say that for some of my colleagues.
And that's what it should be in the judicial system.
Well, it should be and is a different story.
Well, that's what I'm saying. It should be. That's the way it should be. But how many times is it not like that? What's the percentage of it that feelings get involved? And so you're voided of feelings, basically. You need to be voided as a judge of feelings.
Well, no, you have a subliminal effect. It has a subliminal effect.
But what I'm saying, you said you never ruled ever.
I can't remember ever ruling in favor of somebody because I liked them, or ruling against somebody because I didn't like them.
Okay, but how often does it happen? How often? What's the percentage you think?
Often.
Well, what? 30%? 20%?
Oh, I couldn't quantify it, but I know that when you hear
like what?
Look, there are many days when I was hearing 10 short trials, literally, in a day.
Yeah.
And you don't get a lot of time. You just don't. Not in small claims. You just don't get a lot of time. And you say to yourself as you're going through it, what do you believe? What don't you believe? You get a subliminal feeling about who's credible or not. You're deciding credibility. That's strictly a judgment call. Somebody who's lying to you, and you catch them, their credibility on other issues is affected by that. You don't tend to believe them because they've already lied to you once. That's why it is so dangerous, especially in a criminal case. I generally did not put on my clients, the defendants, to testify in a criminal case.
Yeah.
I mentioned it before. The reason is they usually shoot themselves. And they don't remember details. It was 4 years ago, and they want to cooperate or they don't, and they say something and they get caught, and it's boom, and the closing argument is, listen, this is what he just told you. He lied to you. If he lied to you about this, then he's obviously going to lie to you about that. There's a jury instruction that talks about a witness willfully false should not be believed in the rest of his testimony unless, and there's a caveat for it. But the bottom line is, if you're a criminal defendant, unless there's a really extenuating circumstances, sit in your chair and keep your mouth shut.
Yep. You know the prosecutors are licking their chops, man. When defendant goes and testifies for themselves.
It's kind of, as I said many times, I'm not really political, and I'm pretty neutral about most everything. But I can't imagine anybody letting President Trump testify in front of anything because he has a tendency to somehow find alternate facts. And if he does that and it's provable in front of either the FBI or a special investigator, whatever it is, that's a separate crime.
Do you think he's going to testify against with Robert Mueller? Do you think he's going to go be there? What's your gut?
I have no.
Yes or no?
I wouldn't let him do it.
You wouldn't let him do it,
no,
right?
I wouldn't. I would take the political flack that he would get for not doing it.
Right.
But then again, he didn't produce his tax returns, and nothing's ever really happened about that either.
That's true.
So it's better. Look, I've had situations where people have destroyed evidence. And the reason that they destroy the evidence, like there was some gate log showing delivery of trucks in Arizona on a case, they disappeared. The ultimate excuse was the cat peed on them. That's truly a story. Well, they were in the shack where the drivers came in and the cat peed on them and we threw them all out. And whatever. Well, you know why they didn't produce them, because it would have shown the dates that stuff came in.
Of course.
And so that's what happens with a lot of evidence. It just disappears.
Yeah.
So you have to be really wary. The trial work is very difficult. It's tactical, strategic, and it really puts it to you. So I guess that's it for today.
Great job, Judge.
Well, I enjoy this. I'm glad you talked me into it, Gary.
I don't.
You did. The first time I met you, you talked me into it.
Oh, please, come on. All right.
But I'm glad.
Oh, thank you. I'm glad you're glad. All right. You ready to go?
See you next week.
All right. It's Judge Herb Dodell. If you have any questions for him, you want to get some advice, go to askjudgeherb@gmail.com and get his book, From the Trench to the Bench, Amazon.com. Judge,
See you next week.
KCAA Loma Linda, 1050 AM, 106.5 FM, and now 102.3 FM.
I'm Tom Busby, CNBC. We haven't seen fear like this on Wall Street in several years. Investors dumping out of the markets today, sending the Dow to its biggest point loss ever, down 1,175 points at the close, enough to wipe out all the gains made this year. The Nasdaq down 273. Today's big plunge sparked by worries about rising inflation and possibly higher interest rates. The Fed meeting again next month. But now another rate hike may not happen just yet. The White House issuing a statement after the market plunge saying the president is focused on long-term economic fundamentals which remain strong, and they do. In other news, the CEO of Lululemon suddenly resigning today, effective immediately. The company saying only he fell short of its standards of conduct. Broadcom now offering $121 billion to acquire chipmaker Qualcomm. And Arby's, now the owner of the Buffalo Wild Wings restaurant chain. Tom Busby, CNBC.
Only one event unites the world. The 2018 Winter Olympics.
And there it is! Shaun White double gold. Boy, does he deliver.
See the world's best.
Lindsey Vonn is a gold medalist.
And see the world at its best.
To the finish, the Caleb Schifrin wins gold for the U.S.
The 2018 Winter Olympics, coming February 8th, only on NBC.
If you have hard water, the Lime Scale not only leaves white spots, it clogs pipes and breaks down appliances, costing you hundreds of dollars in energy and wear. Eliminate Lime Scale and other water issues like brown staining, bad odors, and lead with HydroCare water products available from Wave Home Solutions. Wave's affordable systems don't use salts or chemicals. You'll love the way your water tastes, smells, and looks. Satisfaction guaranteed. For more information, go to goodclearwater.com. That's goodclearwater.com.
News, weather, and talk on KCAA 102.3 FM, broadcasting to the Moreno Valley, Corona, and Riverside.
NBC News Radio, I'm Brian Shook. Wall Street is reeling from the Dow Jones Industrial Average's worst single-day drop in history. NBC News correspondent Stephanie Rule explains why the Dow was up so high to begin with.
Part of the reason they were on such a tear was the fear of missing out. President Trump is the best salesman of the economy out there. And he talked a humongous game about tax reform. He talked a humongous game about deregulation, and people were excited about it.
The Dow lost 1,075 points, shattering the previous record of 778 points lost in September of 2008. The Dow has dropped over 1,200 points over 2 days. The sell-off is being led by the healthcare and energy sectors. The House Intelligence Committee is expected to vote soon on whether to release a Democratic memo opposing Republican findings on reported surveillance abuses. A GOP memo released last week outlined alleged surveillance abuses by the FBI in an effort to target the Trump presidential campaign. President Trump and the ranking Democrat on the Intelligence Committee are having it out over Twitter. Sharon Reed has that story.
Congressman Adam Schiff is firing back at tweeted criticism from President Trump, who, in a mid-morning tweet, accused the California Democrat of being one of the biggest liars and leakers in Washington. Schiff then responded, tweeting, "Mr. President, I see you've had a busy morning of executive time." That's a reference to reports that Trump spends his morning watching cable TV news and tweeting during the period listed as executive time on his official schedule. Schiff wrote the president should spend less time watching TV and tweeting false smears and more time solving the funding crisis and protecting dreamers. Sharon Reed, NBC News Radio.
The clock is ticking down to another looming government shutdown. The federal government runs out of money again late Thursday. Congressional negotiators are working on another short-term funding bill as they continue efforts to strike a deal on a long-term budget. You're listening to the latest from NBC News Radio.
So, you want to be in show business. Do people tell you that you're really funny, you have a great personality, and you should have your own talk show? Many of us have been told that, but we don't know how to get started. It's easier than you think. Let the pros at Cali Vegas give you a free talent evaluation. Call 949-445-1119 and learn how quickly you can create, produce, and host your very own talk show.